Hello, everyone, and welcome. Welcome, everybody. Thank you so much for being here today. We're going to have a great turnout. And welcome to the recent developments in HOA law, MCLE. And we have the honor of having Jay Brown as our speaker today. And before we get started, I'm going to go over a few bits of housekeeping. First thing, this is a CLE presentation. And for those of you attending live today, you will get a certificate of attendance from the law library once we verify who actually attended. If you are attending today's session and you dialed in, please email us with your name, phone number, and bar number in order to receive your certificate. Again, you'll only need to email us your name, phone number, and bar number if you're joining us via audio and dialed in. You should have also received a handout for the presentation today. If you did not receive the handout, please email us at info@sdlawlibrary.org. Also, if you are watching the recording of this video on YouTube, we unfortunately do not provide a certificate to the recordings, but you can access the self-study log on the BAR's website, and there is a link in the description box below. Okay, so back to those of you attending live today. This is an interactive session, and you can ask questions by using the Q&A button at the bottom of the screen. And under the Q&A button, you can ask questions anonymously or with your name, whichever you feel more comfortable with. And finally, at the end of the session, you will see a link to a survey. And if you could, please just take a moment, fill it out, and we greatly appreciate it. All right, that's all I have, and I'm going to turn things over to Jay.
Great, thanks, Rianne. So we're here today to talk about recent developments in HOA law, and in particular AB130. That was probably the most significant bit of legislation that came down last year. So my name is Jay Brown. I'm an attorney up here at Community Legal Advisors. I've been practicing law for a little over 30 years. The main focus of my practice is homeowners associations. So I would ask if you recognize my name or Community Legal Advisors, if you are a client or have a matter with us, if you please refrain from asking any particular questions regarding that issue, because obviously I won't be able to tell or won't know. Anyhow, just want to avoid any sort of conflict. So anyhow, the goal today is to give a little background on HOAs, some resources for you, some new legislation that came out, and some case law that would help you in your practice if you represent HOAs or are representing an owner against an HOA. So homeowner association growth. As you probably all figured out, homeowner associations are here to stay. We've got some facts and figures in the following pages that will illustrate just how large an industry it is. And then some surveys. You can take it with a grain of salt if you want, because they're conducted by the Community Association Institute Foundation. But it generally shows, and it has all these years, that most residents are satisfied with their homeowners association experience. I grew up in a homeowners association. It was great. I live in a homeowners association. I don't have any issues with it, except that they keep wanting me to run for the board. But anyhow, most homeowners, according to these surveys, are satisfied with their experience. The next slide shows a breakdown by state of the number of homeowners associations, and it's pretty amazing. Over 14 million residents in California live in an association. So when you factor in the fact that they need property managers, landscapers, reserve specialists, pool maintenance in a lot of instances, all these other industries that feed into homeowners association, you can see that it's a big economic engine. And a lot of power is wielded by homeowner associations and homeowner association boards. Um, the next slide shows some national data. 33% of US housing is in community associations. $417 billion in economic contributions. So you can see when the homeowner association industry, when I started 30 something years ago, it was very small. You could still buy a new home on the coast that wasn't in a homeowners association. Now, you know, new homeowners, they're pretty much relegated to buying a condo or a small single family home that is within a homeowners association, if you're buying here along the coast. Some associations, just as a interesting fact, the largest homeowner association, Poinciana Villages in Florida, covers 47,000 acres. It has over 27,000 homes, over 300 businesses, recreation parks. I mean, these are massive developments with a lot of money flowing into the coffers of the homeowners association. And at least here in California, there's no education requirement for the volunteer boards of directors. And that's where attorneys and property managers come in. We need to help the boards properly handle all those funds that come in, even in the smaller homeowners associations, where you're only paying maybe $100 a month. Those sums add up, and you hopefully the boards rely upon qualified property management companies. Then they come to us for any issues, but it's a big a big responsibility for these board members. And as an attorney, I take that responsibility to advise the board, keep them, hopefully keep them out of trouble, let them rely upon experts, CPAs, reserve specialists, so forth, so that they don't run into issues where a homeowner will think there's something nefarious going on with how their money is being spent. The next slide shows is kind of a statistical review. It shows the growth of homeowners associations over the years. So it's been incredible growth. I don't know that there's any sign it'll let up anytime soon. Cities love them because it shifts the burden for amenities and oftentimes to the homeowners association to do some of the infrastructure, provide recreational areas, maintain open space, things like that, which is a relief for the government agencies to shift that burden. So the information, the next slide shows that information is all derived from these surveys and information gathered from the Foundation for Community Association Research, which is part of CAI, which stands for Community Association Institute. Most homeowners associations, or at least property management companies, are members of CAI, and I would encourage you, if you represent a homeowners association or property manager, or even are on the board of directors, that you explore joining CAI. They have a lot of great information available online. They do, classes. They have meetings. San Diego has its local chapter. So anyhow, I would encourage that. So the goals, the next slide, the goals for today, to give you a quick outline of some of the resources that are available, sources of law, some recent cases, and some recent legislation. So first off, resources on the next slide. And I still throw this volume up there. It's a CEB book, or not a book. It was a book when I started. It's a multi-volume set now, advising California common interest communities. And this is a great resource for attorneys that are looking to get involved or represent a homeowners association. Lots of practical advice in there, forms, and so forth. CAI, like I've already mentioned, they have a lot of great forms and educational programs. There are all sorts of various law firm websites that also provide information. You can certainly Google, HOA law, and it'll come up with any number of homeowner association attorneys, whether it's for the HOA or more and more law firms are cropping up that specialize in bringing actions against homeowners association. Call an HOA attorney. When people find out that that's my area of practice, first off, they usually say, I'd never owned an HOA. And if they don't say that, and they do live in an HOA, they'll say, oh, I have an issue or something like that. And I would, I encourage them to, talk to an attorney if they need to. But I would encourage the younger attorneys or any attorney, just call up an HOA attorney, find one of the firms and call. You'll find out that most of the attorneys are willing to chat and give you some direction. Also, I'll give a plug for the San Diego Law Library. Tons of information on their shelves. Helpful librarians can direct you to the resources. Lawyer referral services, another great reference. Well, that's more for the individual homeowners. And I might also add for resources, if you do get involved in disputes with a homeowners association, and it's not a large matter. A lot of the cities have community mediation programs that you can refer clients to for smaller disputes. So next slide. Sources of law. Okay. Just as a refresher, the governing documents, the Declaration of Restrictions. These are what are commonly called the CC&Rs, Covenants, Conditions, and Restrictions. These CC&Rs cover, the use of the property, property regulations. You got the bylaws. The bylaws take care of elections, nominations, things like that. They're incorporated, so there's an articles of incorporation, rules and regulations. If you're going to be representing an owner or a homeowners association, make sure you get copies of these documents. That's going to be the first place your first resource is the governing documents. Get copies, get any amendments, do a quick search of the county recorder's office to make sure you have all the amendments. Because I can tell you, the property managers often don't have copies of the amendments. So make sure you get those. Civil Code Section 4000 at SEC, that's the Davis-Sterling Common Interest Development Act. Civil Code Section 51, this is the Unruh Civil Rights Act. This is where you go if you have a senior community, 55 and over. A lot of the provisions regarding those communities are found in Civil Code 51.3 and those that follow. Corporations Code, like I said, most of these HOAs are incorporated. If you have a mobile home issue, condominiums for mobile homes are popular. It's Civil Code Section 798 and the sections that follow. If there's an issue regarding solar installation, there's specific requirements on prohibitions, excuse me, on what the HOA can do. So look in Civil Code Section 714, 714.1. And then also overlaying all this are the county or city codes. Like, for instance, Carlsbad has a no smoking ordinance now, which is a great tool for homeowners associations here in Carlsbad because it gives you another hammer to hang over people's head if they're violating any of the no smoking provisions. So yeah, and then finally, case law, obviously. So still the two probably seminal cases in HOA law, Narstead versus Lakeside Village Condo Association. This one was a, lady had cats. Cats never got out, but the board found out she had cats. It was a no pet condominium back before that rule was changed. Excuse me. And she the issue came down to could the HOA enforce the no pet provision, even though these pets, it wasn't a dispute. These cats never got out of the unit, didn't bother anybody. But the court said anyone who buys a unit in a common interest development with knowledge of its HOA's discretionary power accepts the risk that power may be used in a way that benefits the community but harms but harms the individual. So it looked to the impact on the HOA because, and in this instance, in a condo development, you don't want large dogs running down the hallway that might injure people. So even though this lady's cats didn't pose a threat, the court determined that the HOA could enforce the restriction and because they looked at the benefit on the whole to the homeowners association. So the court determined that it can enforce the restriction unless the challenger, in this case the lady, can show that the restriction is unreasonable because it's arbitrary, violates a fundamental public policy, or imposes burdens on the use of the affected property that substantially outweigh the restriction's benefits. So the court weighed those factors and said, nope, Lakeside Village can enforce it. The other seminal case is Lambden versus La Jolla Shores Club Dominium HOA. And this is kind of interesting just because it's a club dominium rather than a condominium. But, excuse me. In Lambden, it was a dispute regarding termite treatment. Miss Lambden wanted, tenting essentially. The HOA hired experts who recommended spot treatment, and they went that route with spot treatment. Miss Lambden didn't like that, filed a lawsuit, and the court in the next slide set forth the rule of judicial deference. And the rule of judicial deference says if the court won't step into the shoes of the board as long as the decision was made by a duly constituted board, right? They were, properly elected, and they're sitting as a properly elected board. They conducted a reasonable investigation. In this case, they explored the various options for termite treatment, and their decision was in good faith and with regard to the best interests of the association. And finally, they said if the board exercises that discretion, within the scope of its authority regarding ordinary maintenance decisions. So this is the Lambden rule of judicial deference. I apologize, losing my voice a little bit. And this is still good law. And like I said, this along with Narstedt are two of the seminal cases in HOA law. The next slide, I just threw this in here. ADR. In homeowner association practice, if an individual homeowner wants to go to IDR, which is called internal dispute resolution, the HOA cannot refuse to participate. The code section says it can send a board, it's supposed to send a board member. Oftentimes it'll be a property manager and a board member. Attorneys can be involved. I'm not a big fan of that because I think it makes the process too formal, and kind of defeats the purpose of trying to resolve issues in-house. But anyhow, it's required. The board have to meet at a reasonable time and hold their internal dispute resolution. There's no requirement that a meeting, that a resolution be accomplished. I get board members that are intimidated by an IDR, and I have to remind them that you don't have to go in there to settle the case. You're going in there in good faith to see what the issues are, to see if there's a possible resolution, but if there's not a satisfactory resolution, then there's no requirement that you enter into any sort of agreement. And then finally, ADR, mediation or arbitration. HOA is required to offer mediation or arbitration. Usually it's mediation before filing a lawsuit, unless the suit's solely for declaratory relief, injunctive relief, or writ relief, or for that relief in an amount less than small claims jurisdiction. So yeah, that's ADR. I'm a big proponent of mediation. I've been doing this a lot of years. I've been through the mediation training. I've been a mediator. Mediation is great for resolving HOA disputes. It's so easy now, especially on Zoom, for people to coordinate their schedules and participate. I still think in person is probably more effective, but a lot of the mediators are not doing in person anymore. But for an HOA dispute, excuse me, I think it's great because it forces the parties to get together. They're still going to have to live with each other after the mediation, so there's a strong incentive for them to resolve it. So moving on, case law. This first case, I'm going to butcher this name, Nabat Mama versus Ross Morgan and Company. So in this case, the HOA, and the Ross Morgan is actually their property management company, imposed fines of $106,000. I mean, I feel uncomfortable when HOAs want to impose fines of more than $500, but here this HOA is trying to collect $106,000 for various violations. So Nabat, the plaintiff, he thought that the Fair Debt Collection Practices Act should apply, and he sued. So the Fair Debt Collection Practices Act applies to debt collectors, and the Fair Debt Collection Act defines a debt as any obligation or alleged obligation of a consumer to pay money arising out of a transaction, which the money, property, insurance, or services which are subject to the transaction are primarily for family or personal or household purposes. And it's limited to consensual transactions. So what the court said in this case was that they weren't consensual. Here, the HOA didn't consent to a violation of their rules, and the defendant or Nabatma didn't consent to the imposition of the fines. Therefore, it it wasn't subject to the Fair Debt Collection Practices Act. Now this is good language for the HOA in regard if you're trying to collect fines. Moving on to the next one, Woolward versus Regent Real Estate Services. This is another case where there's some good language for a homeowners association. And as an HOA attorney, I can tell you a lot of what we do is try and resolve disputes between homeowners and determine whether or not the HOA needs to get involved in the issue in the first place. So this case actually involved tenants in an HOA, and the tenants allege that the HOA should have done more to prevent the altercations. There was punching, there was kicking, there was assault with a flashlight, there was a stabbing, there were allegations of long-standing harassment, and no action by the HOA or the property management. So the court took a look at it and they said, you know what? We're not going to impose a duty upon the homeowners association to intervene and attempt to resolve the disputes between homeowners or their tenants, because that would place an untenable burden on the HOA. They're volunteer directors. The HOA can't compel owners, much less tenants, to sit down and work out their differences, and can't adjudicate their differences except in limited context of violation of the HOA governing documents. The court said the HOA doesn't have police powers, doesn't have subpoena powers. They can't compel the owners to do things unless it's set forth in the governing document. So the court said imposing a duty under these facts would leave associations liable for the outcome of such disputes without the tools to prevent them. This would leave ordinary homeowners holding the bag when special assessments were needed to pay judgments or attorney's fees. I said property management and the HOA played no part in the physical altercation at issue here and should never have been dragged into the dispute. So it found there was no existing duty of care that was breached by the HOA or property management, and it sustained a summary judgment. And I have down here, why don't residents call law enforcement? I can't tell you how many times a homeowner will call the property manager and say, hey, my neighbor's threatening me. He showed me a gun. He says he's going to do harm. And they'll call the property manager. And I'm always amazed at that. And I tell the property manager, have the homeowner call the police first, make a report. But anyhow, this is excellent language for homeowners association to establish that they don't necessarily have a duty to get involved in these disputes. The next slide is Arroyo versus Pacific Ridge Neighborhood HOA. And in this one, it's an election case, essentially. And it has to do with the use of the HOA media, access to that by, in this case, a board member subject to recall, and whether or not she could have something sent out with all the ballot materials. So in this instance, the court said, when the HOA invited members to run for replacement board position in the recall election and included with its notice and ballot materials a candidate testimonial advocating that members vote for him upon a successful recall, the HOA is obligated to give other members equal access to advocate their point of view, so long as it was for purposes that are reasonably related to the recall election. And This stems out of Civil Code Section 5105, which talks about election rules and about access to media, and that it ensures any candidate or member that's advocating a point of view can have access to that media. So the court said, yeah, this material should have been sent out or included with the homeowners association. But then the court said they're sending it back to the trial court to determine if or if the HOA can establish by preponderance of the evidence that even though they didn't comply with 5105, did that noncompliance affect the results of the election? So that was an interesting case regarding elections. The takeaway from this, I think, is that when board members or when the HOA is conducting an election, they need to be transparent and err on the side of allowing statements. The HOA can also, put in their own statement if they want to, or at least disclose that the statement that's submitted by this candidate is not the view of the HOA, things like that. But be very careful and, err on the side of allowing things like that. The next case, Ridley versus Rancho Palma. This is a terrible one. This was an over a 60-day bench trial. And this one just, there was what turned out to be an uncapped well under this condo development in the crawl space. And the condo was bought by an older couple who wanted to use it as, rent it out and use it as retirement income. So, there was, water intrusion issues, mold, things like that. And they determined that, it had been built over this abandoned well. The board, hired experts, had them come out, give reports, but then they failed to provide some of those reports to the homeowner. They ignored expert opinions. And then the court determined there was substantial evidence that the HOA acted with indifference to the dangerous consequences of its conduct. So this is pretty extraordinary. And it imposed, it stated that traditional defenses of judicial deference in the business judgment, right, Lambden, the factors we went over, didn't apply because the board failed to conduct reasonable investigation. Well, it didn't. It did conduct investigations. It just ignored them. But the big factor was that the HOA and the board president did not act in good faith. So in addition to, the fees and costs, the HOA was ordered to reimburse the homeowners for lost rent and utilities. And just as a side note, typically if a homeowner has to get out of their unit for some reason so that the HOA can go in and make repairs to the common area or an area that they're responsible for, those costs are typically borne by the homeowner. But I think because of the lack of good faith and the breach of fiduciary duty, the court said, no, the HOA needs to pay these. So moving on to the next, there's just some additional cases. Casamira, HOA versus California Coastal Commissions. This was a seawall case. I think it's up in Half Moon Bay. The court basically said if the structures existed prior to the Coastal Act's effective date, then they are okay and can be repaired. But if newer construction, not entitled to the same shoreline armoring. This other case is Bird Rock Home Mortgage versus Breaking Ground. This one involves non-judicial foreclosures. So I don't know if any of you do collection work for HOAs, but if you do non-judicial foreclosures, take a look at this case. It says in non-judicial foreclosures, there's a bidding requirement. Bidding is required to remain open 45 days for qualified buyers to submit bids. A qualified buyer did submit a bid within those 45 days, but the court determined that they were going to treat HOA liens as mortgages, and therefore Bird Rock had sued saying, hey, they're the rightful buyer. They had submitted their money. It shouldn't have gone to this extra time, 45 days. But the court said, no. We're going to treat the liens as mortgages and therefore give an extended bidding period. Next case is Lipton. This one happened right out in Fairbanks Ranch. Tennis court case. The owners discovered that their retaining wall and lighting and so forth on their tennis court was not was needed repair. So they hired somebody. They repaired the retaining wall, but they also needed to take out bamboo, which screened the tennis court. And they reinstalled, replanted slower growing bamboo. The neighbors didn't like it. They could still see the lights. Didn't really screen the court. But the HOA just dragged their feet. The court said that, or the court found that the CC&Rs required the owner to replace the bamboo hedge within a reasonable time, and that was the main issue. They weren't forced to put the screen back up and shield the tennis courts within a reasonable time. It said the HOA failed to uphold the restrictions by not requiring the owner to replace bamboo hedge in a timely manner. The HOA was free to enforce the restrictions governing screening of tennis courts in the manner it saw fit, but it was not entitled to fail to enforce the restrictions. So in this case, the restriction said you need to screen it, and there was just too much of a delay. That's not a published case, but it's notable in that if you want a judicial deference, you need to act within a reasonable amount of time. Moving on to legislation, there was a substantial number of new legislation that came out. Electric vehicle charging stations, the owner is no longer required to list the association as an additional insured. That was typically how we handled those. You can still require the owner to sign a maintenance and indemnity agreement and have that recorded, requiring the owner, to maintain insurance and also to maintain and repair and replace the charging station. Next one is balcony inspections. This is Senate Bill 410. Some members and prospective purchasers are now entitled to view the balcony inspection reports. These reports are required, I believe, every 9 years, and associations should have had an initial inspection report done by 2025. And it applies to units that have 3 or more attached units and an elevated balcony stairwell that are essentially supported by wooden structures. I would advise going in and taking a look at the specific requirements if you have an HOA as to what is included and which HOA is required to have that inspection. So those inspection reports are now the seller is obligated to provide it to a buyer. and it also includes a cover sheet. And that's where it gets kind of property managers don't like that because they're hesitant to complete those forms and the cover sheets because they're being asked to identify components as posing immediate safety risk. Um, so anyhow, that's a new change. JADUs, look at Senate Bill 543. I'm kind of running slow on time here, but rebuilding after disaster, this adds a couple of civil code sections. Essentially, an HOA can't slow down or stop the process of a homeowner rebuilding after a disaster in substantially the same manner as the home that was there before. And then finally, we get to what everybody in the HOA world has been talking about, AB130 on the next slide. And I apologize, my copying and pasting abilities weren't that great. But anyhow, AB130 slipped into law July 1st. It was part of a budget bill, became effective immediately. The HOA industry was caught by surprise since it was slipped into a budget bill. But anyhow, it's now law. So as all the headlines say, the new civil code sections 5850 and 5855, they limit fines for violations to $100, excuse me, unless the board makes a written finding of adverse health or safety impact in a board meeting open to the members. That's kind of problematic in and of itself. You know, usually when boards meet to consider fines, they do it in, or they used to do it in an executive session. It's for privacy of the homeowner. But now, after this, there's a question as to whether or not these hearings will have to be in open meetings. The homeowner can request that it be done in executive session. But if the homeowner doesn't request, it's an open question as to whether or not it needs to be done in an open meeting. So the easiest part of this whole section is that there's $100 cap. Unless there's an adverse health or safety consequences. As usual, the devil's in the details, and the legislature didn't help the industry too much by defining, what the big issue is: continuing violations. Because as all these years, if a homeowner was parking illegally, in a guest spot overnight, the HOA could escalate the fines without having gone back to a hearing necessarily. $50 the first time, then it goes up to 100, 150, so forth. Is that still applicable? Parking in a guest spot, let's take that. Is it a violation each time the homeowner parks there, right? Because he cures the violation when he backs out and leaves for the day. Is it a separate violation entitled to another $100 fine when he pulls back in? We don't know. I think the consensus in the HOA industry right now is that, yeah, those are separate violations, but it hasn't been enough time. There's no case laws filtered down yet. This schedule work, this code section works great for architectural violations, right? When somebody doesn't submit an architectural application, there's the violation. And it's $100. But for some of these continuing violations, it's a little dicey. So what we have done at our office is when we do an amendment to the rules, which is required under this code section to comply with the civil code, we have a minor violation, which are up to $100. And then we set forth major violations, which are these adverse health consequences. And we go to the board and we say, okay, here are some what we think are major possible health violations, speeding within the neighborhood, um, construction that affects the structural integrity, whatever other violations like that. And then we define those as major violations, and then we put a fine amount above $100. And that's one way we're trying to kind of not get around, but to utilize this rule so that the HOA still has a hammer over the homeowner's head to comply. The other code section, 5855, again here, this one talks about what is curing a violation. So what does it mean to cure a violation? Taking the parking example, if a homeowner gets a violation letter for parking in a guest spot, then he pulls out, doesn't pull back in, till before the hearing, fine, that's pretty clear, it's cured. But then what happens if he, after the hearing, and no fine is imposed, he starts parking again? Does the HOA need to start the process all over? Is that a separate violation? Things like that. Noise violations. Can a one-time house party that disrupts the condo complex, is that still subject to a fine if it doesn't happen again before the hearing? We don't know because supposedly it's cured. This code section also provides that if the homeowner can't cure the violation prior to the hearing, they can submit a financial commitment to cure the violation. Well, what does that mean? What is a financial commitment? I think that might work in the architectural setting if there's a violation. Does the HOA require a signed contract showing that the painter is going to paint the house the proper color, or that a unapproved patio cover is going to be removed within a certain number of days? Do they need the executed contract? Do they need proof that the deposit was made? It doesn't say. And then what's really frustrating is if there's no agreement after the hearing, the member can request IDR. They've always had that right, but it's almost as if the legislature just wants to drag out this process, excuse me, to give the homeowners as many opportunities as possible. And then also one change, they changed the notice after a hearing. The HOA, all these years, you've had to give notice to the homeowner 15 days after the hearing. For some reason, they changed it to 14. So I'm not sure why. But the bottom line is the fines worked for smaller violations, and they will work for smaller violations. But I think ultimately it's going to lead to more lawsuits, more mediations, and you just make the whole process more expensive, and living in a homeowners association more expensive for everybody by by putting so many restrictions upon the homeowners association to impose these fines. So now, I mean, how it used to work is you send a courtesy notice out, say, hey, stop doing whatever you're doing that's a violation. If they don't stop, you call the owner to a hearing. They go to the hearing, and then if there's continuing with the violation, oftentimes there would be like a third letter that would go out and say, hey, you're still, we impose this fine, you're still doing it. We're going to escalate the fine. But now it's going to get referred to an attorney, and then the parties are going to be off to the races. So like I said, I'm not aware of any case law yet on this. Like I said, it's only been around 6 months. But I can tell you that homeowners who are subject to discipline are raising this issue. And homeowners, attorneys are raising the issue. And so the HOA, if you do represent an HOA, you need to make sure that they do an addendum at the very least to incorporate the provisions of Civil Code Section 5850 and 5855. The code section specifically provides for an addendum, and you can just write in there that the addendum supersedes any conflicting provisions in the current rules, and that should be good until they revise the entire set of rules. The next slide, and I just threw this in, excuse me, after watching the news, and actually this question has come up, did come up a couple times last year, about ICE agents or Border Patrol showing up at a homeowners association that has a manned security gate, and also at a high-rise condo where there's a manager down on the main level. So, this question had come up a couple times last year. So the CAI has a good publication. I've listed it there, Guidance for Community Associations Handling ICE Requests. So basically, what we have told the security guard is, you can verify their authority, identify that it's a judicial warrant. There should be a designated board member to contact if they do show up, and then have the security guard gather some info, badge number, copies of documents, write down the details immediately after either allow access or whatever, so that it's fresh in your mind, and then contact legal counsel. What you don't want to do, though, is get in any sort of confrontation. But anyhow, in the events of this week, I thought I would add this slide, and I encourage you all to take a look at the CAI publication. Excuse me, I think I'm getting a cold. So in conclusion, because we're butting up against an hour here, most HOAs provide value. They operate smoothly. Most of them have good property management companies. Property managers are required to they're not required, but they often have a lot of experience and education behind them. But as attorneys, we still need to educate the board members and the property managers as to some particulars, and try and keep them out of trouble, and avoid litigation whenever possible. As most of litigation, especially for a volunteer board member, if you have a litigious HOA, it's going to discourage volunteers and make the HOA much harder to run. And then common sense. You got to remember that your client, as an HOA attorney, your client is the board. There's the HOA that acts through the board, but it's also a community, right? These people all live together. So I try and think, okay, when a dispute comes up, how would this play out in my HOA with my neighbors and try and exercise some common sense and calm the situation down, which is what we're trained to do. But yeah, there'll be more. Oh yeah, I've had down here. Advise disgruntled owners to attend board meetings. This is any of you that practice HOA law, people love to complain about their HOAs. And oftentimes when you ask them, well, have you been to a board meeting? They'll say no. And so we'll say, okay, why don't you go to a board meeting and see what happens? And I've gotten reports back that, hey, I hadn't been to one. The board takes their job seriously, runs smoothly. So I would advise those disgruntled owners to attend board meetings before they run off and hire an attorney or file litigation just to see what's going on. Request documents from the HOA they're entitled to, just so that the HOA can avoid litigation down the road. Oh yeah, that's all I've got for you guys today. If there are any questions, I'd be happy to try and answer them or point you in the right direction. Brianne, we have any questions?
Yes, thank you so much, Jay. So we have two questions. The first one was, who slipped in the $100 into the budget bill?
Who slipped it in?
Yes.
I don't know the particular congressman, but I can tell you it was opposed by, or it would have been opposed by CAI. They had no idea it was going to be put into that July 1st budget bill. But there's the CAI is a big lobby. Congressman, if you can get the ear of a congressman about a grievance, I'm sure there was something in here. Some homeowner probably got fined some crazy amount for a small infraction and got the ear of a congressman. And HOAs are easy targets because, like I said, most people don't like HOAs. They think they're big bad corporations with board members running around with rulers to make sure your grass is the right height. But as to who slipped it in there, I don't know.
Thank you, Jay. No problem. Another question. Any thoughts on the growing automation of property management companies? For example, clients have to do everything through a portal instead of just being able to talk to the property manager.
Yeah, so this has come up recently in a couple of cases I have going on, and the industry standard now is the use of these portals. And there's particular issues here in my cases are when a homeowner goes into collection, right? They're delinquent on their homeowner's assessments. And the matter eventually gets referred to our office. What the property manager does at that point is cut off their access to the portal. And that's to make sure that there's not conflicting figures going out or information going out to the homeowner from the property manager versus our office. And that's standard procedure. I understand their frustration, and I don't think it's related solely to HOAs. I mean, it's tough to get anybody on live on the phone these days. But unfortunately, the way things are going, small property management companies are being absorbed by larger national property management companies, and the portals are going to be here to stay. And I don't like it. I can tell you. I would much rather call up and talk to a property manager, but I'm one of the older ones now. But I don't see where that's going to be going away anytime soon. I think what might be better is if the property managers and the HOAs put it in their rules that the access to a portal is a privilege. It's not a right in the HOA. And if you violate the rules or are um, delinquent, or in some cases, it's just abusive, right? These property managers take a lot of abuse from homeowners, and they sometimes will just cut off access to that portal so they don't have to deal with it. But just make sure that it's in the rules that it's a privilege, it's not a right. Um, but yeah.
Thanks, Jay. We have one more question.
Sure.
Um, I understand that there is a new law that allows HOA to do their elections via email. How does that work?
Wow, yeah, so there is. You can do electronic voting. It's kind of a complicated process, and uh, I think what we have been advising homeowners associations is to kind of hold back on the e-voting for a while and let the inspector of election companies sort out all the kinks. I think it'll probably, um, you know, be very helpful for the larger master associations, where there are thousands of homeowners, and then they can get their quorum. But I can tell you for the smaller homeowners associations, they're still by and large being done by written ballots. But I would encourage you to go to Civil Code. I want to say it's 5100 and so forth, um, regarding electronic voting. The election rules have to be amended to provide for electronic voting. People still can be provided the option of receiving a paper ballot. I mean, it could actually probably lead to more expense because now you've got e-voting and you've got people doing their written ballots. Um, so I would encourage you to go there, and instead of having me try and explain all the process, which frankly I'm not really well versed in it because those are handled. The elections are primarily handled by property management companies operating with inspector of election companies. Uh, and so I would encourage you to go there.
Awesome. Thank you so much, Jay. And Peter says thank you. And just thank you so much, Jay. This was very informative and just great case law and great legislation that now we know about. So thank you for that. And thank you all so much for being here today. And you all have a wonderful weekend.
All right, thank you, Rian.